Everyone in that courtroom expected Karoline Leavitt to fold the second Justice Barrett opened her mouth, but no one saw it coming when she flipped the power dynamic in less than 10 minutes. The marble floors of the Potter Stewart U.S. Courthouse in Cincinnati echoed under the weight of thick shoes and heavier expectations. It was a Wednesday, humid, sticky, and the courtroom was packed tighter than anyone anticipated. Press from every major outlet had rushed in when word got out. Karoline Leavitt had been subpoenaed for a live constitutional hearing regarding Executive Order Finger-Sergiso 92. The order itself wasn't the scandal. It was who wrote it, who signed it, and who had the legal authority to enforce it. That morning, Karoline stood outside the courthouse with nothing but a slim leather folder and a bottle of water. No security detail, no podium, just her and a few quiet moments before walking into a room full of people waiting to watch her stumble. Inside, the air felt different, not warm, not cold, just dense. The kind of silence that carries weight even with cameras humming and whispers floating. Reporters scribbled in shorthand. Law clerks glanced at their tablets. People weren't here for justice. They were here for spectacle. And then came the murmur. Justice Amy Coney Barrett will preside. The announcement struck like a gavel before the actual one did. Barrett was only temporarily overseeing this case due to its constitutional stakes, but her presence meant something bigger. It added gravitas. It also added pressure, especially for someone like Karoline. Barrett was already seated when Karoline entered. The justice wore her usual expression, unreadable but piercing. Karoline walked down the aisle alone, no lawyer beside her, no political handler whispering cues. She passed rows of staffers, legal aides, and political skeptics, each with a look that said the same thing. Good luck, sweetheart. She reached the front, placed her folder on the table, and waited. The hearing clerk called out her name. Karoline Leavitt, Press Secretary to the President of the United States. Barrett lifted her eyes. Miss Leavitt, please state your credentials for the record. Karoline didn't hesitate. Karoline Elise Leavitt, B.A. in Politics from St. Anselm College, former Congressional Communications Director, appointed White House Press Secretary in January. Barrett tilted her head. You're not a lawyer? A small wave of chuckles rolled through the back rows. Karoline ignored them. No, Your Honor, but I've worked alongside constitutional attorneys since my first month on the Hill. Barrett didn't blink. You're not here as a spokesperson, Miss Leavitt. You're here as a witness to the authorship of a document with legal impact. I hope you understand the difference. Karoline met her eyes for the first time. I do. And I came prepared to speak in legal terms, not political ones. There it was. The temperature in the room shifted ever so slightly, just enough for the front row to sit up straighter. But Barrett leaned forward, folding her hands like she had all the time in the world. We'll see. What most people didn't know was that Karoline hadn't slept more than 4 hours in the past 3 days. She'd been reading legal briefs, digging through old precedents, studying interpretations from the Reagan era, and cross-referencing them with federal court opinions from Texas and Pennsylvania. She hadn't just come to show face. She came to show substance. Still, Justice Barrett's opening tone wasn't surprising. She was a master at control, controlling the pace, the tone, the perception. Every pause was calculated, every question a pressure point. Let's start with Section 3 of the Executive Order, Barrett said. Explain to me in plain language what its purpose is and why it doesn't violate the Appropriations Clause. Karoline opened her folder, eyes scanning a familiar paragraph. She raised her head, and her voice came out measured. The section refers to the temporary reallocation of discretionary funds from administrative departments to emergency federal housing relief. The clause explicitly states that the reallocation remains subject to congressional oversight under 31 U.S. Code 1512. Barrett raised a brow. Interesting. You're citing the Anti-Deficiency Act. You're aware of the ruling in Metcalf v. United States, I presume? Karoline nodded once. Yes, Ninth Circuit, 1991. But that ruling concerned preemptive fund transfer without declared emergency status. This executive order followed a federal declaration dated March 9th, which meets the threshold. And just like that, the quiet in the room shifted again. But this was only the beginning, and Barrett wasn't finished testing her. Justice Barrett flipped through a stack of papers, her fingers methodical, slow. The rustling filled the courtroom, though no one dared move. The cameras fixed on her, but her attention was locked on Karoline like a spotlight, bright, harsh, and unrelenting. I'm going to ask again, Barrett said, her voice sharp but even. Do you have any formal legal education beyond legislative exposure? Karoline didn't miss a beat. No formal degree, but I've worked directly with senior constitutional lawyers on policy implications and statutory compliance. I also co-authored the internal brief that preceded the order in question. Barrett closed her folder, lips pressed into a thin line. And yet, you're attempting to interpret federal appropriations law before a constitutional bench. Do you understand how problematic that is? A few people in the gallery exchanged looks. One young man in a light blue tie snickered behind his legal pad. Karoline straightened slightly but didn't get defensive. I understand the scrutiny, but if the issue is the legality of the order, and I was involved in its preparation, then yes, I believe I'm in a position to clarify intent and execution. Barrett paused, letting the silence stretch just long enough to make the room uncomfortable. That remains to be seen. The words weren't shouted. They didn't have to be. Barrett's tone carried more sting than most people's anger. It wasn't about raising volume. It was about tightening the grip. Karoline glanced down for a second, not because she was nervous, but to recenter. She turned a page, found the note she'd prepared days earlier, and waited. Barrett continued. Section 4 authorizes reallocation of Department of Energy funds without specific line item veto. How do you reconcile that with the Consolidated Appropriations Act of 2023? Karoline looked up again. That clause references temporary reallocation, not permanent repurposing. We modeled it after the Emergency Supplemental Appropriations Act of 2005, post-Katrina, when FEMA required discretionary funds to be shifted without explicit earmarking under executive direction. Barrett sat back slightly, fingers interlocked. You're comparing a housing relief bill to a natural disaster appropriation? I'm comparing the legal framework, not the cause, Karoline replied. This time, no one laughed. The press secretary wasn't flustered, she was holding the thread, but Barrett wasn't ready to let go. Do you even understand what you just referenced? Or are you regurgitating something someone told you to say? It hit like a slap. Even people in the back looked up from their phones. Karoline's hands remained steady. I understand the precedent, she said quietly, and I've reviewed the language of Public Law 109-62 line by line. If you'd like, I can point out where the language in our order mirrors the flexibility outlined in Section 101. A few heads in the audience slowly turned toward Barrett. The justice's jaw shifted slightly, but she didn't show emotion. Proceed. Karoline reached for the second sheet in her folder and laid it flat. Section 101(b)(2) of PL 109-62 allowed federal agencies to reprogram funds in excess of original allocation due to unanticipated exigent needs. Our executive order includes the term emergency-level urban housing crisis, which under the National Emergencies Act allows the president to issue directives based on classified reports from the Department of Housing and Urban Development. Barrett interrupted. Are you attempting to argue legal necessity based on classified documents? Karoline shook her head. No, I'm arguing legal structure. The classified content isn't relevant here. The classification itself is. Under the Federal Records Act, once an agency justifies internal reporting at classified level, that triggers a procedural exemption which validates discretionary redirection, assuming proper documentation is filed within 7 days. The court reporter lifted her eyes. That level of procedural clarity wasn't common in testimony, especially not from someone without a law degree. Barrett didn't respond immediately. Instead, she picked up her pen and tapped it once against the folder, then again and again. Finally, she said, So, in your view, the administration did not overstep, but fulfilled a legal duty within the scope of established emergency protocols? Yes, Karoline said, and I'm prepared to walk through each subsection with specific statutes that support that interpretation. Barrett's eyes narrowed, not out of anger, but curiosity. But she wasn't done, because this wasn't about law anymore. It was about control. Barrett shifted in her seat, a subtle movement. But in a room like this, subtlety speaks volumes. She didn't glance at her law clerks. She didn't ask for a sidebar. She simply lifted her pen again and said, Very well, Miss Leavitt. Since you are so comfortable with statutes, let's talk about precedents. Do you recall Berenson v. United States, 2003, Ninth Circuit? Karoline didn't hesitate. Yes, the ruling addressed executive overreach in the absence of congressional notification, but the case was vacated 2 years later following an en banc review. It lost its standing as binding precedent. Barrett stopped writing, just for a second. That response wasn't rehearsed. That wasn't a script. That was someone who knew exactly what she was talking about. Interesting, Barrett replied. So you're citing non-binding precedent as part of your justification? No, Karoline said. I'm using it as a reference for context, not justification. The distinction matters. A quiet came from somewhere in the second row, but it died out as quickly as it started. Karoline turned a page in her notes. But if we're talking binding precedent, I'd be happy to refer to Sheffield versus Department of Treasury, 2009. The Fifth Circuit upheld executive authority to reallocate funds temporarily during a fiscal crisis, provided that the redirection remained within the agency's broader mission. Barrett tilted her head again. That case involved Department of Labor funds during a strike, not housing relief. Karoline met her gaze. The agency's mission was the dispute. The court ruled the mission was fluid in a time of economic volatility. HUD faces similar volatility now, documented in 4 consecutive quarterly reports. The room was dead silent. A balding man in a gray suit leaned back slowly in his chair, arms crossed, but his eyes locked on Karoline like he was seeing her for the first time. Barrett didn't raise her voice. She didn't frown. She simply tapped her pen once more. Miss Leavitt, are you representing the administration's legal position today? No, Karoline answered. I'm here as a witness, but that doesn't mean I came unprepared. There was something in the way she said it, casual, steady, unshaken, as if she wasn't standing before a Supreme Court justice in front of millions of viewers, as if this were just another press briefing, except the podium had changed and the stakes were higher. Barrett leaned back. Then I have to ask, who helped you prepare this testimony? Karoline paused. No one. Barrett blinked. No legal team? I wrote the brief myself. I verified the citations using public databases and internal legislative records. I cross-checked each case with both the Congressional Research Service and 2 academic law reviews, one from Stanford, the other from Tulane. Barrett stared at her for a beat too long, not because she didn't believe her, but because she did. Stanford and Tulane, Barrett repeated. Karoline nodded once. Stanford Law Journal, March 2022 issue, page 78, and Tulane Law Review, August 2021, page 203. Both cover emergency executive authority and interagency reallocation under constitutional scrutiny. Someone in the press pool actually gasped, quietly, but audibly. Because by now, the entire courtroom was beginning to realize this wasn't just a young woman defending a policy. This was a dismantling in real time. Karoline didn't just belong in the room. She might be the sharpest one in it. Barrett's voice softened, barely. And what made you prepare like this? Karoline didn't smile. She didn't smirk. She just looked up and said, because I knew no one would expect me to know anything, and I didn't want to waste their low expectations. Barrett didn't speak, not right away. For a fleeting second, she glanced at the gallery, and then back at Karoline. But while the courtroom sat stunned, Barrett still had one more trick waiting, and this time she was aiming straight for the technicalities. Barrett's fingers tapped against the wood again, but slower this time. The rhythm had changed. The challenge was still alive, but something underneath had shifted. The silence between questions was no longer a trap. It felt more like calculation. She leaned forward, eyes fixed. Let's address the procedural timeline. The Department of Housing and Urban Development issued its internal alert on March 6th. The executive order was signed March 9th. How do you explain the 3-day turnaround when interagency review typically requires 7? Karoline didn't blink. The review was expedited under Code of Federal Regulations Title 44, Section 206.35. The clause permits immediate internal coordination when emergency declarations are filed under the Stafford Act. Barrett pursed her lips. And you're saying HUD's alert meets Stafford criteria? Karoline flipped to the 3rd page of her notes. Yes. The alert included population displacement risk projections in 5 major cities, 3 of which, Phoenix, Dallas, and Fresno, surpassed FEMA's actionable threshold for imminent housing instability. Someone near the back coughed, a sharp and awkward sound, as if surprised to hear those cities named with such precision. A camera operator leaned in just slightly, refocusing the lens. Barrett took a breath. So you're familiar with FEMA response protocol? To the extent that it intersects with executive response authority, yes, Karoline replied. And I'm aware of the limitation under Section 404 of the Stafford Act, which is why the executive order specifies temporary funding mobility instead of direct agency overreach. A law clerk behind the bench scribbled something fast in a notepad. Another looked up, stunned. For a courtroom that had started this hearing expecting spectacle, or possibly a mild embarrassment, it had transformed into something else entirely. Barrett folded her hands again. Miss Leavitt, if I may ask, what was your role exactly in drafting this executive order? Karoline paused just briefly, then said, I outlined the policy implications and drafted the initial framework. The Office of Legal Counsel reviewed the language, but the structure, how it would function between departments, that came from me. Barrett raised her eyebrows. You're not an attorney, yet you drafted the interdepartmental structure of a document that affects billions in federal funding? Yes, Karoline answered. Because I was the only one who understood how the communication lines between HUD, FEMA, and Treasury had failed during the last round of appropriations. I didn't need a law degree to see the gaps. I needed logic and memory. That landed hard. A pause followed, this time from Barrett. It wasn't just that Karoline was answering well, it was that she was speaking from somewhere deeper, somewhere that wasn't about performance. The justice studied her for a moment. Then, with a shift in tone, she asked, Do you remember what happened during the 2019 shutdown, the housing freeze? Karoline's eyes didn't waver. I do. I had just moved to D.C. I watched a pregnant woman cry in the lobby of a government building because she couldn't get a voucher approved. I promised myself that if I ever had the power to prevent that kind of breakdown, I would. Barrett leaned back slowly, lips parted but silent. No one spoke. Not the clerks, not the press, not the judge. Karoline had just drawn a line, not just between law and politics, but between power and empathy. Between what's on paper and what happens when that paper affects real lives. The courtroom wasn't looking at a spokesperson anymore. They were looking at someone who had crossed an invisible threshold, someone who could fight legal fire with legal fire, but who also remembered the faces buried in the bureaucracy. Barrett broke the silence. I have no further questions at this time. But her voice was different now, quieter, thoughtful, almost careful. But just when it seemed the storm had passed, Barrett asked one more question, one that no amount of case law could easily answer. Barrett picked up a sheet of paper she hadn't touched until now. Her voice was steady again, but cooler. Miss Leavitt, you've demonstrated considerable knowledge of legal framework and federal process. But let's move past the surface. Who authorized the language in paragraph 12? Karoline flipped forward. The paragraph regarding discretionary override authority? Barrett nodded. Specifically, the clause granting the executive branch provisional allocation rights without oversight for a 30-day window. Karoline tapped her pen once, then answered. That clause was added in response to internal delays during the COVID-era stimulus deployment. It mirrors language used in Executive Order 13910, issued in March 2020, which permitted the immediate redirection of resources related to public health infrastructure. Barrett pressed. But health infrastructure and urban housing aren't legally parallel. You're stretching interpretation. Karoline's jaw set slightly, not in defiance, but in preparation. Respectfully, I disagree. The legal principle isn't about the sector. It's about executive authority during time-sensitive crises. Whether it's ventilators or temporary housing, the mechanism of urgency remains. Barrett looked directly at her now. Miss Leavitt, are you aware that such a clause, without a built-in congressional check, could be seen as a constitutional breach under Article 1, Section 9? Yes, Karoline replied calmly. That's why we included language triggering automatic congressional review if the 30-day limit is exceeded. It's a provisional measure, not a bypass. Barrett raised the paper again, but this time her tone was pointed. That language is buried in a footnote. Karoline nodded. Footnote 7. That was intentional. It allows the administration to act first, but remain accountable, without slowing down emergency response. Transparency and velocity are often at odds in federal action. The footnote was our compromise. Barrett didn't speak immediately. She set the page down slowly, eyes never leaving Karoline's. You realize, she said at last, that kind of legal maneuvering can be construed as deceptive? Caroline's reply came quickly. It can also be called adaptive governance. That hung in the air like an uninvited guest. Not hostile, just undeniable. A beat passed. 2. Then Barrett asked the question no one was expecting. Are you afraid of what this will cost you? Caroline seemed almost startled, not by the question itself, but by how human it sounded. Yes, she said quietly, but I'm more afraid of what it'll cost the people we serve if I don't speak. And that was it, the flashpoint. Not the law, not the policy. The moment she made it clear, she knew the risks, and still stood her ground. The cameras were still rolling. Millions were still watching. But something about the moment felt smaller, intimate, like the tension had turned into mutual recognition, not agreement, but understanding. Barrett didn't respond with another question. She simply exhaled through her nose and leaned back in her chair. Across the room, even the most jaded court correspondents were silent. One older man, badge hanging from his neck, laptop halfway open, just watched her. Not typing, just watching. And for the first time in that room, no one was waiting for her to fail. Caroline wasn't just holding her ground. She was reshaping the ground itself. Barrett finally said, "We'll adjourn for a short recess before final statements." The gavel hit the sound block with a firm, single knock. Caroline gathered her papers slowly, methodically. As she turned, one of the junior aides standing in the corner whispered to a colleague, "She's got more in her than half this room." Caroline didn't hear it, but she didn't need to. But recess wouldn't erase what had just happened, because when court resumed, the balance of power wouldn't be where it started. When court reconvened 20 minutes later, the room didn't sound the same. The rustling was subdued, conversations were hushed, and most notably, Justice Barrett returned to the bench without the same edge in her movements. She adjusted her robe, glanced briefly at the audience, then returned her attention to the woman standing before her. Caroline looked calm, but behind her composure, the exhaustion was creeping in. Her water bottle was empty. Her shoulders were still square, but her fingers curled slightly over the edge of the folder now. Still, her expression didn't change. If she was tired, she didn't show it. Barrett cleared her throat. "Miss Leavitt," she said, her voice steadier than before. "Before we move to closing remarks, I have one final question, purely for clarification." Caroline nodded once. "You've said the administration acted within legal bounds. You've defended the structure, the timing, and the process. But tell me, why not leave it to the lawyers? Why insert yourself at this level?" Caroline held the silence for a moment before answering. "Because when policy fails, it's not the attorneys who face the people. It's the ones who stood behind the podium and made the promises." She paused. "I wrote the order. I believed in it. If it's going to be dissected, I need to be the one holding the scalpel." Barrett didn't look away. There was a subtle shift in her posture, less rigid, more grounded. "You've answered every question with clarity and confidence," she said, "but confidence doesn't always equal correctness." Caroline allowed herself the smallest smile. "I know. That's why I came with citations." Soft laughter rippled through the courtroom, not mocking, not sarcastic. Genuine. A release of tension that had been building for over an hour. Barrett glanced down, shuffled her papers, and then looked up again. "You're not a lawyer, Miss Leavitt, but today you spoke the language better than most I've seen." Caroline lowered her eyes for a moment, then met Barrett's again. "I wasn't trying to impress anyone. I just didn't want to be dismissed before the first sentence." That line hit harder than the footnotes, harder than the cases, because that was what every woman in the room heard loud and clear. Barrett gave no verbal reaction, but she sat in silence for a long time. Then she turned to her left, toward the secondary judges in attendance, and spoke quietly. "This court thanks the witness for her testimony." Caroline gathered her notes, her folder now slightly creased from her grip. She stepped down from the front and turned to exit. No applause followed, no music. Just the quiet sound of acknowledgement that words can sometimes carry more force than power itself. As she walked past the gallery, reporters watched her go. Not as a spokesperson, not as a figurehead, but as someone who had just redefined what that role could be. On her way down the corridor, a producer from one of the networks whispered to his assistant, "That clip's going to run all week." And it did. Within hours, the video flooded social media, but It wasn't cut into sound bites of confrontation. It was a full segment, unedited. People didn't share it for drama. They shared it because they saw something rare. Someone standing in front of power, not trembling, not grandstanding, just showing up prepared. Across the country, university law students were watching. Young girls in government classes watched. Even critics, even the talking heads who'd rolled their eyes at her appointment, were admitting on camera that they may have underestimated her. And as for Barrett, she gave no interviews. But a week later, in a closed-door symposium at the University of Notre Dame, she referenced an individual who taught the bench that legal brilliance doesn't always wear a title. Karoline never commented on it. She didn't need to, but the story wasn't about going viral. It was about rewriting expectations in a room built to silence voices like hers. 2 weeks later, Karoline was back in D.C., walking through the West Wing like any other day. The video had already surpassed 18 million views. Her inbox had ballooned with messages from law professors, political analysts, students, and strangers. Some praised her poise. Others asked for copies of her notes. A few just wrote, "Thank you." But Karoline didn't care about the attention. That hearing had never been about proving herself to the internet. It was about something quieter, more personal. She sat down in her office and flipped through a letter she hadn't opened until now. It was handwritten, thick paper, no return address. Inside was a short message. "You reminded us that knowledge isn't about the title in front of your name, but the preparation behind it. I don't know what you'll do next, but whatever it is, don't lower your voice. A former clerk." She smiled and folded the letter gently, placing it inside her top drawer. Outside her window, a group of interns walked past, laughing about something light. They didn't know what she just read. They didn't know that behind the curtain of protocol and structure, everything had shifted just slightly in their favor, because someone had shown that age and experience don't always outrank clarity and grit. Later that day, during a routine briefing, a reporter asked if she planned to study law now. Karoline paused, then answered with a slight grin. "I think I just gave my bar exam in front of the entire country." Everyone laughed, but she meant every word. She had no plans to go to law school. Not because she couldn't, but because she didn't need it to validate what she already knew, that power respects preparation, not just pedigree. What mattered more than anything was that she had walked into a room where she was expected to stumble, and instead, she'd forced that room to adjust to her pace. She didn't demand respect. She earned it, one statute at a time. At a speaking event a month later in Tempe, Arizona, a high school senior named Leona stood up during the quanda. Nervous, voice trembling, she asked, "How did you not panic when someone as powerful as a Supreme Court justice tried to dismiss you?" Karoline took a long breath before answering. "I didn't focus on who she was," she said. "I focused on what I knew. Because when someone tries to shrink you down, the only thing that keeps you standing is your preparation and your memory of why you started." The audience fell silent. Not because it was poetic, but because it was real. She wasn't there to be admired. She was there to remind them that no room is too big when you carry your work like armor. In the months that followed, law schools began referencing her testimony as a case study in applied knowledge. Not just for the legal arguments, but for the way she stood still while others tried to shake her. And Barrett? She never addressed the moment publicly again. But behind closed doors, her tone about Karoline shifted. She no longer referred to her as a communication specialist. She called her simply that woman who knew her case better than most lawyers do. It wasn't flattery, it was recognition. Karoline never chased power, she chased preparation. And it turns out, when you do that long enough, power starts listening. The lesson is simple. Show up ready, even when no one expects it, especially when they don't. You don't need permission to know what you know. You just need the courage to say it out loud. If this story moved you or reminded you of your own strength in unexpected places, don't forget to subscribe for more. Real stories, real lessons, and voices that refuse to be ignored.